All right. So about 35-ish people here on the webinar right now. Thanks everybody for coming to the Q3 or end of Q2 privacy webinar. For those of you that are not familiar with Reklaim or me, I'm Neil Sweeney. I'm the founder and CEO of Reklaim. Reklaim is a technology company that specializes in trying to give consumers access, control, and optionality around their data. You can check it out in the App Store or online. So the intention for today is to spin through kind of the most relevant changes in privacy and how they impact this crazy digital MarTech, ad tech industry that we work in. We've got the experts here to help kind of navigate us through it. So I'll turn it over to maybe Mackenzie, ladies first. Why don't you give us a little bit of introduction on yourself, and then you can pass it to Ben, and either of you can kind of outline what your company actually does, and then we can dive into the topics.
Great, thank you. I'm Mackenzie Thompson. I am a California barred attorney and work with Ben at In-House Privacy Inc. We specialize in privacy law with a focus on ad tech, tech at large, really in that marketing space with a lot of our clients. I work with Ben. I also work at a privacy consulting firm in a non-legal role, really taking the law that I practice with Ben and implementing it for my clients on a day-to-day basis. I also volunteer with the California privacy law section. I've worked with IAPP in the past, and I'm happy to be here.
Thanks. Hi, I'm Ben Isaacson. I've been a privacy professional since 1996. So I've been around the block a few times. As with Mackenzie, we both privacy attorneys as well as consultants, in-house privacy as well as Lucid Privacy is their consultancy, where we do sort of more strategic privacy by design and other types of consulting. I've been working in with a lot of data companies for a long time, marketing companies, data brokers, agencies, and very familiar with obviously the ins and outs of ad tech and marketing tech.
Okay, great. So there's lots to cover. I've got some buckets, so we can kind of pick them off one by one. If there's one in particular that you'd like to talk to first, we're happy to do it. So I've got Washington on my list. I've got Oracle on my list. I've got SPI, or sensitive personal information, on my list. You can't have a list without some mention of the cookie, so that's technically on the list too. And then I've got on the list AI, data, and privacy. So if there's one there that you guys want to jump at first, otherwise I'm happy to kind of work through them. I definitely have my preferences, but I'm happy to be guided by the experts here.
Let's go with your preferences.
Okay, let's do Washington, because I don't think anybody knows what the hell is going on in Washington right now. And I think it's what we've seen in the market is a lot of confusion around the new privacy policy specifically to Washington. So maybe as a starting point, let's just outline the basics here. Like, what is this policy? What's it called? What does it impact? And then I think that's naturally going to spin off into a handful of other questions, such as who does this impact? How do you market in those, how do you market in that jurisdiction, and so forth. So Mackenzie, maybe do you want to start off on this one?
Yeah, so the Washington law, it's called My Health, My Data. It's an interesting law in the sense that it takes the existing state privacy laws like a CCPA, and it bridges the gap between those and HIPAA. So its intent was to cover health information that isn't necessarily collected by the covered entities of HIPAA, but that also CCPA or the other state laws don't touch. My Health, My Data, the Washington law, is a bit more treacherous because it does have a private right of action, and because the definition of consumer health data is so broad, it encompasses anything. And I guess generally this law and then other laws like it define consumer health data as anything that might reveal past, present, or future mental or physical health conditions. It also explicitly includes tracking technology. So anything like an IP address that you discover on a website that might collect or allow you to infer health information, that consumer health data. So it has a really broad definition of consumer health data. It encompasses tracking technologies, and it has this private right of action, which makes companies fearful of it and generally just prohibit collection of data from Washington consumers, full stop.
So just kind of a couple of pieces of clarification. Just Ben, I know you're kind of ready to jump in here. Just private right of action, meaning that an individual whose data is being used to be targeted specifically in Washington could file a class action against the entity that is using it. Is that correct? Yeah.
Right,
Okay.
individual
Yes.
or class, yeah.
Okay. The other thing that we've sort of seen here as it relates to this, and again, I'm just trying to give some real life examples. My experience has been I've seen this freak out a lot of CPG firms where they've had consumer products going from everything from shampoo to soap to face cleanser for acne, you name it. And these have been sort of general market products that they've, put tons of dollars behind historically. Now they feel like they're on kind of roller skates. They don't know if their acne face wash is considered a health product and is therefore in violation of what is going on specifically in Washington. So we've seen this knee-jerk reaction where they've taken this, again, acne face wash. They've now fear that they're actually infringing on this. And so they're just removing Washington entirely from their marketing mix. So we'll talk about that kind of concept of exclusion a little bit later, but can you guys just maybe, what am I getting right in that analogy and what am I getting wrong in that analogy as it relates to like CPG and the reclassification of their products and what they need to be worried about specifically as it relates to Washington?
Yeah, and I think you hit it on the head earlier where there's a independent new privacy policy, the Consumer Health Data Privacy Policy, that is required under this new law that is entirely duplicative with everything you've already been saying to your customers for, since the inception of the web, that now Washington prescribes, that, I just posted in the webinar chat, you can look at an example for P&G, right? P&G is not a HIPAA compliant, I mean, maybe they are for one of their divisions, but like you don't think of their products as requiring the collection of sensitive personal information or anything, protected health information, anything that would be typical of, a healthcare company. But in this case, it could be acne medicine, it could be, or just cleansers that are just good for your, skin. So yeah, the law is so broad that P&G had to publish this example that, again, doesn't say anything really new and different than what they've been publishing in their existing privacy policy, but now needs to be called out independently to avoid the risk of being sued based on lack of transparency or lack of, specific choices even with regard to use of that information. So every company that has anything related to do, with Washington, mental or physical health, should have one of these privacy policies now posted.
Okay, my feeling is they don't. So I feel like there's a lot of catch up that has to happen here. Mackenzie, anything to add to that? I had one other question specifically on this topic before we can probably vent out of here.
Yeah, I think the language, like I touched on, the definition of consumer health data is so broad, and the very nature of this law is meant to be broad. So I think that makes it scarier when it comes to this potential for private litigation. But Ben and I were at a conference last year where we were speaking to someone at the Washington AG's office, and they seemed surprised that, and Ben, this is your story, you can jump in whenever. They seemed surprised that, we thought that it could encompass things like toilet paper or acne medicine. So the Washington AG has an FAQ on their website that it states, like, the law isn't meant to cover things like toilet paper. That wasn't our intent, which seems reactive to, the idea that, well, that does fall within the definition of consumer health data. And I'll put that FAQ in the chat.
I guess I would add just, I mean, the sheer fact that there has not been, as far as I can tell, consumer privacy litigation around this, and to date, no class actions, no, that relate to this particular issue that we've been concerned about. So that maybe they're just waiting for somebody to start the ball rolling, but so far so good, I think.
Yeah, I mean, I don't think anybody wants to be the first. So I think that's the fear, is that most companies are pretty good at trying to limit liability. So if the way to limit liability right now is to remove Washington, I guess they kind of have to. Um, the other kind of thing that we've seen here is, so well, maybe let's step back. So we've seen another example of this notion of exclusion, and again, I don't know which part of it is correct versus not, is that whether it's platforms, DMPs, individual agencies, et cetera, we've seen this strategy of exclusion happening. So this idea that, hey, I used to market in Washington, the privacy policy's now changed. I don't know where I stand as it relates to this policy, so we're out, meaning we're excluding it. We've also seen this manifest in other jurisdictions like Nevada and Connecticut, primarily, where we've had conversations with particular clients, brands, platforms, et cetera, where they're like, we're not touching these markets. We're not touching Nevada. We're not touching Connecticut. We're not touching Washington. So I don't know if we have to focus specifically on those states, but is Washington an outlier and sort of sits out on its own? And are there other states that have similar private rights of action that mirror what's happening in Washington that would give that same tactic of exclusion relevancy?
None of the others laws have the private right of actions. There's no private litigation. I think it's Nevada and Connecticut, and then next year we'll have Maryland. So those are all enforced by their state attorneys general. So it's not as scary, but they do have very similar provisions.
For private right of action, or just how they're classifying consumer data?
How they're classifying consumer data.
Okay.
Yeah, I mean, the only, really two states that outside of Washington that we've seen a lot of litigation is Illinois with their biometric privacy law, which has been the most litigious, I think, of any US state privacy law ever in the history of privacy. And then California has a broad-based Invasion of Privacy Act that goes back decades, that is now being used tactically by plaintiffs' attorneys against primarily the metapixel and other pixel tags generally. But again, that's more of a shakedown than a real privacy risk.
Yeah, I want to come back to that topic, but just before we pivot off this, so just so that everybody is clear here as it relates to the differences between Washington and the others, can we summarize it as saying that Washington is the single state that has the private right of action, but that Connecticut, Nevada, and Washington share similarities in how they qualify or describe what is defined as consumer data, and that latter component might be what is spooking other CPG firms or whatnot to kind of avoid those two states as well as Washington?
Correct. That's exactly right. I think another thing that scares people, though, is there's this heightened requirement for any sort of sale of personal data. So Washington, you have to have written authorization from a consumer to sell data. I think that's also true for Nevada, and then the Maryland law that's coming up. It's the same. It's a written, well, that's not true. Sorry. For the Maryland law that's coming up, it is prohibited to sell sensitive personal data unless you have some direction from the consumer to sell the data. The other law, Connecticut, I believe it's an opt-in. You have to have consumer opt-in consent. So it's not as strict as written authorization. But that's another thing that I think spooks a lot of companies.
So this notion of sort of excluding states, I guess the obvious piece of the equation is, I'm a marketer, I'm a CMO at a Fortune 500 company. My consumers are throughout the United States. I'm now being told by my legal team or my privacy team that as of now, we should be eliminating specific states because we don't know where we stand. I guess the obvious question is that in the short term, maybe that works, but in the long term, taking huge chunks of the US population away from the marketing mix doesn't seem to scale. So if I was a CMO today, and I don't know, I'm the head of Unilever or P&G or one of these firms, how do I market in Washington? Like can I market in Washington? What do I have at my disposal here? And what are the types of firms I could be looking at versus, the historical kind of headless data companies that might not necessarily have the consent that's required to operate in those markets?
I mean, I think the first thing really is defining that consumer health data. What are we really talking about here? Is this whatever skincare product really in scope here? And I think that's what, again, that link that you provided, it should be really carefully reviewed as far as what the Attorney General's perspective on this is. Because that's number one, like, yes, there's a private right of action, but ultimately that shouldn't drive your marketing plan. Your marketing plan should be driven by, am I compliant with the law? Not just am I scared of litigation? And I think that's where, a good counsel will advise you on, the four corners of the law, where your products fit into that, where your campaign might fit into that. What are the tactics like geofencing by IP address or whatnot could you consider to at least attempt to comply with, with the law if you believe that product is in scope? And not, again, I would not let litigation drive the decision at this point, and really blanket remove, the whole state from marketing, and or the whole country from marketing based on that one state. That sounds extreme to me.
Right. Okay. So I think it's fair to say, though, that if trying to do anything in those states, making sure that you have explicit consent from the individual consumer, whether that's direct and or through a partner, is obviously foundational to any marketing initiative, and that if you're arbitraging consent through a third party, that's probably not going to fly going forward.
It's going to be trickier. The third party is going to be trickier. On the first party data, yeah, there are consent management platforms you can work with that have more express consent modules that you can implement for those states, or yeah, you rely on some contractual assurances that you're getting consent appropriately.
Okay, cool. Let's maybe go 1 degree to the right here a little bit and talk about sensitive personal information, because this seems to have inflected over the last 12 months. So SPI, or sensitive personal information, let's maybe start at the beginning. What is sensitive personal information? What is classified as sensitive personal information? I think it would be helpful kind of for everybody if we took some examples, and maybe if we focus specifically on multicultural. I know that from our point of view at Reklaim, we seem to have this conversation more often than not, with multicultural audiences being reclassified as sensitive. The other comment, which I think would be helpful for the group, that if you guys could explain, is how this is inflected and where it might have started in one state. It's now, I think it's at, I'm going to get it wrong because it seems to be moving around so quickly. I think it's at like 18 plus states. And just how quickly this reclassification has kind of manifested through the rest of the US. So I don't know who wants to start with the basics around SPI, what it is, and then kind of we can use multicultural as an example. And I think the same idea is, how's it impacting the Coca-Colas of the world or the Pernodes of the world who actually want to target these audiences, which represent, in the case of multicultural, 40+% of the US population.
You want to start there?
Yeah, I can start us off. So generally, these states define sensitive data very similar. I think to your point, Neil, a lot of these states are very similar in how they are defining sensitive data and treating sensitive data, with California being a small little outlier. And then we saw Virginia, and then Colorado was very similar to Virginia, and Connecticut was similar to Colorado and Virginia. And now we have, to your point, 19 state laws that have been passed, and most of them do define sensitive data similarly and have the same rules. So generally it's data revealing race or ethnic origin, religious beliefs, consumer health data, sex life, national origin, citizenship, genetic or biometric data, and then children's data, as well as precise geolocation data. So the variances in the law are opt-in versus opt-out. I think there are only 2 states that are opt-out. So California is opt-out, Utah's opt-out, and then the other 16 or 17 states are an opt-in requirement for collecting and processing.
And let's just pause
data
there quick on that, Mackenzie, because this also, I find, gets confused a lot of the time, because like this notion of assumed opt-in or assumed consent versus explicit opt-in. I think it's important for this because this often gets bastardized a lot in the market, which is like, oh, my partner has consent, but it's like there's no visibility on where the consent was. I think the other gap specifically is this notion of arbitraging consent. If you collected consent over here, can you use it for this purpose over here? Or like, do you have to actually capture consent with the visibility of where it's going to be used and how it's going to be used? I think that notion of consent gets very muddy for everybody in the industry. And I think that would be helpful if we could just be very clear that this is not a cookie notification, accept all piece, we're good. I think there's more detail associated to this.
Correct. There does need to be some notice that states the purpose that you're collecting and processing the data. And any use outside of that purpose is, I mean, what we call a secondary use. A couple states have different terms for it. And you do have to get explicit consent for any secondary uses. Ben, I don't know if you have anything to add on that.
Yeah, I mean, again, this question of like what is a sale as well under with SPI in particular, and is a pixel tag, any third-party pixel tag a sale? I think generally we've come to that conclusion is that if it is an advertising pixel tag, it is automatically a sale, and if your web page includes maybe a form or anything that might generate an SPI category, you could conceivably be selling that data without consent, and even a cookie banner isn't going to be the right level of consent for that sale, because you need a higher level of consent than is typically presented in a cookie banner. So that's where I think again, those CMPs are trying to build these modules now to create some sort of express written consent, sort of like TCPA we had to go through for phone numbers. But that's really what's required in order to provide that derivative, advertising use case.
On the CMP side, is the CMP just solving that gap specifically for the publisher? I'm assuming the answer to that is yes, but knowing that there's so many other platforms and vendors outside of the publisher, through the waterfall, whether it's the DSP, the DMP, so on and so forth. With those companies not having access to a consent management platform, at least from my point of view, I can see how a publisher using those tools can help solve those gaps. I'm confused as to how the traditional DMP or some of these other platforms actually solves these gaps and are just not these giant pools of inevitable liability.
I mean, I think you're raising an interesting point because we've been dealing with this in Europe for quite some time, with their opt-in consent requirements for cookies, and sort of each regulator in Europe sort of raising the bar a little bit to get to this place now where the IAB's transparency and consent framework is so prescribed as far as what needs to be in that consent. We're nowhere near that yet in the US, but it should be there, to your point, where, similarly to Europe, where you see this consent management, interface, it's not just, hey, opt into cookies. It's like, no, we're actually going to sell your data to this DSP, this DMP, this ad network, this data broker. You can choose which ones you want to accept or not, where it is express written authorization or consent for each of those derivative uses, and not just for that publisher, generally to use for whatever purposes are buried in their privacy policy notice. So I think we're moving in that direction, where that, if there's going to be an SPI consent presented, it will be specific and offer, different choices depending on the different use cases.
Yeah, I mean, I guess is the trend here where this notion of kind of reclassifying data. I mean, I'm taking the previous conversation specifically around Washington and that type of data, and now there's this increasingly growing category of SPI. Like, I've always used the analogy, like you have this giant bucket of data, which it kind of crosses all the various different categories of data. And it's not all moving necessarily directly to this explicit opt-in, but it seems as though somebody's kind of reaching in and pulling out a category and pulling it over and putting it into an explicit consent bucket or a My Health, My Data bucket or an SPI bucket. And so slowly but surely, it seems as though more and more data is moving out of the general data bucket into this higher compliance bucket, or this bucket that requires higher compliance. I would say it wouldn't be a trend if this was just happening with, say, SPI data. But from my vantage point, it seems to be taking shape in a lot of different forms. Like, again, the reclassification of data for my health, my data, or now some of these expanding categories in SPI. Do you guys see this as more categories are going to find their way into that new bucket that SPI and health data is sitting in? Or do you think that there's an inevitable kind of cutoff point in that you're going to have some data that's going to sit in the sort of the traditional bucket, and it's only going to be these rare categories that are going to be over in the higher compliance bucket?
That's hard.
Do you want to answer
I
that?
mean, we've seen in like the FTC enforcement around location data lately. We've seen in blog posts that the FTC seems to think that just like browsing data should be treated as sensitive. And then we saw in the first draft of the APRA, the federal privacy bill, that they had classified just browsing data as sensitive. But I think there's been a lot of pushback. And then we saw in an executive order that was supplemented by a DOJ a memo that, the presidential office doesn't think that browsing data or browsing history is sensitive data. So I think we're finding that line where we're not categorizing things as sensitive anymore, but there is a slippery slope to your point. Like, people are trying to categorize a lot more things as sensitive, but we're butting up on that edge.
Yeah, and on the data broker side, I mean, I think we've seen some pretty dramatic responses. I've seen with clients like just wiping out data sets completely that had for maybe just at the state level, and in some cases completely nationally, based on hey, we can't really geofence this, so we're just going to get rid of it, and start looking at well, hey, can we start building this back in with the consent approach so that it all fits the model. But it's going to be a slow roll to do that, and again, not nearly at the same scale that we've been accustomed to for the last for generation really. So it's going to change dramatically.
So, I mean, this past quarter we saw Oracle leave the market, and there's been a lot of attention put on this. I think first of all, in Oracle's defense, when you're a $16 billion company running a $300 million data business, probably not the best use of your time. But I think what's interesting is that, when they did shut it down, it was only a few weeks later that it was kind of discovered that there was quite a big fine that they had received specifically around privacy. I think it was somewhere in the 120 million. I don't think we need to necessarily focus specifically on Oracle, and I don't think that maybe that privacy fine was the reason that they decided to leave the market. I think the bigger question that I have here is Oracle has always been a big player in the space. For them to kind of close up shop and leave, it just, to me, it begs the question of how do these traditional DMPs operate in this increasingly litigious world with really out an interface that allows them to kind of manage opt-in, opt-out, so on and so forth. That's just more an interesting piece for me. I mean, I appreciate that they've always been a big part of the ecosystem, but the ecosystem seems to be changing quite quickly. And I've always wondered how these firms are going to be able to figure that out without an ability to manage that. I don't know if you have any thoughts specifically around the future of the DMP and the ability to remain compliant in an increasingly privacy-driven world.
Yeah, I mean, Oracle's a unique case. I mean, again, it wasn't exactly a regulatory fine. It was really a class action or plaintiff's claims. So it was a private, civil settlement that they agreed to. And yes, that it was extreme as far as the terms of that settlement, where they were disgorging data, and like similarly like to what we've seen with some FTC consent decrees of, again, just like literally deleting all the data that you've been using for that purpose. Again, I don't know that that's the greatest example. The better example that I think that comes to my mind was California's consent decree with the state of California, the AG, with DoorDash. Now DoorDash had been licensing their data to third-party data co-ops for the purpose, or data, brokers, for the purpose of, their own performance marketing, their own lead gen campaigns to try and build off of others in that co-op. And they weren't transparent about it, didn't offer choice, and the AG really found against DoorDash, not against the data licensors, like the data brokers. Oracle may have actually been one of those, I believe. And I think that's what's really most telling here, is that the regulators really do want to find the DoorDashes of the world as examples of companies licensing data without permission, without any opt-out choice, without any transparency, and take them to task for it. And I think that's a signal that every brand marketer should be very keen on before, and scrutinize, every pixel tag on their website and every type of data licensing relationship, including for AI, which, we'll get to maybe later, because there's all this new AI, language getting put into commercial terms that may or may not be in conjunction with their privacy terms, and could be violations of their own, practices. So, there's a lot going on there. Oracle, again, I think it was BlueKai, the acquisition, and even some of the, the other acquisition, Datalogics, I think it was, like, they were never a great fit in the company. I think they're not exactly a tech stack here. But yeah, they could have sold those businesses instead of deprecating them completely. I think that was an odd choice.
If you're a DMP today and you've kind of watched Oracle, I mean, obviously the short-term strategy is that $300+ million is going to find a new home relatively quickly. But I still question this idea about, well, there's still a half a dozen kind of large DMPs sort of operating in the space. They're all full of data, including data from places like Washington, including multicultural data. I mean, they're very good at bringing data in. They're not necessarily very good at removing data once it's been in there. And so that's always the question, is that as data has been added into these DMPs for years and years and years, and now the privacy laws have changed, what's the process here to kind of take the data that's potentially sitting inside of those platforms and make sure it's actually compliant? I don't know how you do that. Like, I'm like, okay, so it worked in the past, now it's changed. It just seems like you're sitting on a powder keg. I mean, I'm clearly biased on this one, but I don't know. Can we just quickly talk to that? I know we've talked about it individually a little bit about kind of the pixel stuff that's been happening. I think this is also a really important piece. I think, your comment there around DoorDash and that settlement is really important for the brand marketers that are watching this, to just be very careful about kind of where you're moving your data around. But we know that there's also sort of the issue with, having pixels on sites and that turning into a bit of a shakedown where that data is actually being collected. It's really essential for people to, run performance marketing, but in having these pixels as a third-party pixel, they're also potentially running afoul of their law. Like, can you explain this one, Ben, a little bit more?
Well, I mean, these pixel tag lawsuits, there's sort of two, I guess, variations of them. I mean, there's some more flavors, but there's the California Invasion of Privacy Act, which is this age-old, decades-old law that really predates pixels, but provides for, sort of a wiretap type protection for Californians. And so anytime you have evidence that there's some third party that might be benefiting from your communication with the first party, you potentially could sue. And so that's what we've seen, these factories of plaintiffs, litigators suing anybody who's got a metapixel, and partially because the metapixel provides the plaintiff's attorneys with evidence that they have shared the information with Meta through their off Facebook activity tool, which is, its own sort of powder keg that I actually predicted when it first came out would lead to this, because they really didn't need to provide that level of transparency through their privacy preferences, but because of Cambridge Analytica and all these other things, they wanted to be more privacy centric. So they've actually created this plaintiff's attorney factories based on their own data that they're collecting. But they're not being sued necessarily. They have some lawsuits, but it's really every website that puts the metapixel on that that's a California-based company because that's who they're going after. Again, mostly for settlements. They're not actually trying to go to court. They just want some money. So that's kind of one flavor of it, and there's a few other versions of it for chatbots and for some other sort of analytics type, session replay type tools. So they're all sort of in the same genre of these sort of, I don't know what you call them, shakedown type, claims. The other one that certainly, and I just saw an article this morning about it, is the Video Privacy Protection Act. And any website that has video on it that is sharing it, also again with Facebook or Meta, has a federal private right of action around, the pixel tag collecting the nature of the video content, sharing that with Meta, and allowing that publisher or advertiser to retarget based on that content through Meta, or it could be through any other platform. It could, including Netflix, Hulu, like any CTV platform. So, so there's a lot more to unpack with that. We're not going to spend the time, I think, going through it, but those litigation claims have been a very mixed bag in different courts in the U.S. on successful, defense of those claims, depending on the nature of, are you a videotape service provider or not? And that's really the fundamental question, for those publishers that are capturing that video. And it's a tricky issue, and not crystal clear because, again, it was based on the 1980s video VHS tape law, not the 2024 pixel tag uses.
Okay. Mackenzie, anything to add to that, or we can move to another topic?
Yeah, I think it's interesting that, especially the SIPA, the California claims have resulted in a lot of companies getting opt-in consent for cookies, similar to sensitive data or pixels rather, when the law isn't opt-in consent. It's another one of those creeps into getting a heightened consent.
Yeah, interesting. I've got a couple other topics. I'm conscious of time here. So do we want to spend a couple minutes here specifically talking around cookies? I think we have to do that. It's almost like part and parcel of any kind of privacy. So we all know that this narrative has started, stopped, and is kind of on pause. With Google kind of pausing on removing cookies, there's been some thoughts that they're going to mimic the similar opt-in, opt-out that Apple introduced in the iPhone with advanced ad tracking. Any thoughts from a privacy perspective or from a legal perspective around Google's changing of their mind and or this possible implementation of making it a consumer choice at the individual website level versus removing cookies altogether from Chrome?
I mean, I'm fascinated by the idea that they're going to just completely disintermediate all consent management platforms through the browser, which maybe would have made sense 20 years ago, for them to implement. I don't know how great it is for them to do that now, because your experience now that's ubiquitous on every at least website that's supported by ads or using ads proliferately. That Google can somehow present their own consent, or it just doesn't really make a lot of sense to me. I think it's the devil's in the details, but it doesn't seem like it's something they're going to be able to pull off without a lot of pushback from the industry on.
If they move that way, does the consent management platform on the publisher side become redundant, considering it's getting captured at the browser level through Chrome?
I mean, for sure. That's why it confuses me. I mean, we tried this back in, again, 20 years ago with Microsoft and Explorer, and this dates me, I guess, with the whole do not track thing, where, they were really presenting something similar in the sense of like, well, let's reverse cookies so that it requires notice through the browser, and the default is do not track. And the whole industry went bananas, right, and pushed back hard on IE, and then at the same time Chrome was kind of coming up. So I would suspect the same thing here, especially since Google is actually an ad-supported company. I don't know how they would really be able to pull that off without the industry pushing back.
Mackenzie, any thoughts on that?
No, I think he summed it up pretty nicely.
Okay, cool. So you can't have any webinar or any conversation these days without talking about AI. So for me, from my vantage point, when I kind of look at what's happening in the AI space, there's a lot of noise and there's a lot of conversations regarding the training of models. Um, Training of models requires data. It's always been the perspective of like Reklaim that data is, the property of the individual consumer, and yet you see these articles where YouTube is being scraped to power data, or there's New York Times is selling their entire catalog, or Reddit is cutting deals with AI. To me, it seems as though that the AI and the training of AI models seems to be on this collision course with privacy. And the from my vantage point, it looks as though that the AI companies almost kind of know this, and that they're running as fast as they can to gobble up as much data before legislation comes in to actually stop them from doing it, knowing that the government tends to be slow on the trigger, and that by that time they're going to be big and powerful and be able to defend themselves. Are we on a collision course here with legalities, privacy, and AI? And maybe some of those thoughts that I put forward, like what's real, what's fantasy, what do you guys think as to what's progressing in the space here?
I'll start us off. It's definitely on a collision course with privacy, though interestingly, if you look at the laws that have been passed, it's really just the EU AI Act and then Colorado's new comprehensive AI law. They aren't centered around use of personal data. They're centered around risk associated with the AI systems. There's like high risk systems and risk. Those are generally things like systems used for scoring individuals, things that would like associate with a risk to an individual. It's not so much about the ingestion of personal data. So I don't think the laws that we have now really, I guess, prevent or regulate that collision with privacy, though we are waiting on some rulemaking in California around automated decision making, which I think will actually touch that intersection.
I wonder if that automated decisioning law in California becomes the new CCPA, where it's sort of like the beginning of sort of this rollout of similar type of legislation in other jurisdictions across the US. I mean, I don't know if that's what's going to happen, but that's how I've interpreted it.
Yeah, perhaps. I mean, I wouldn't be surprised if it's effective, if other states copied it, or I mean, because it's such a hot issue, AI is such a hot issue, if there isn't just a federal AI law that comes around and automated decision making. But yeah, we see a lot of copycatting in the state privacy laws. And I also wouldn't be surprised if because this California rulemaking is one of the few laws that does touch this ingestion of personal data, if the CPPA, the California Privacy Protection Agency, enforces it with a very heavy hand because no other state can.
Interesting.
So we work on a lot of commercial terms, related to data, and this notion of, this personal information is not included, is sort of a misnomer in the sense of, most of like the DPAs and everything that we negotiate also includes confidential information. And there's a blurring of the lines in the AI use cases around the personal and confidential, because that confidential, trade secret information. I mean, everything. If you look at the definition of confidential, it's quite broad. And so the notion that you can, I can just, it's not personal. I can use that for AI training purposes really breaks, I think, most of the commercial terms. And I think that's where we're seeing a little bit of a bigger friction in the marketplace now. And so I work with, one very large enterprise, and we've created this like AI sort of addendum that includes all these restrictions on software companies, who are, potentially going to have access to this confidential information and what they can and can't do with it. And again, it's becoming much more again, adding more words to paper, I guess, is the simple way to say it, which is not what everybody wants to hear from a lawyer. We need to add this other addendum on top of this DPA that we've negotiated now, for a decade, and it's going to just require more negotiated friction. But that's really where we're going here, is making sure it is clear that this isn't just about personal and just about privacy.
Cool. Okay, as we kind of run up on time here, just as we look into the back half here of 24 and into 25, there's things like the election and other stuff that's happening. Anything here that you've got your eye on that that you think might be coming down the pipe here shortly that we should be aware of or keeping an eye on? Anything that jumps out at either of you?
I mean, I think right now, with the election, going on, and we do work with a couple of agencies and some political, advertisers, that, the micro targeting of political ads and the analytics and retargeting around those really voter specific reg files and whatnot is fascinating to me. That we've gotten to a point where, again, using the same sophisticated tools that big brand advertisers are using are now capable of being used by any campaign at a very granular level. I think there's sort of this split between, like, we talked about the brands and sensitive information and all the risks to those brands, but we don't have that on the political side. They are targeting using all of that data broker data, everything in their disposal at a very individual level. Across every platform you would be using on a commercial level, and there's not any pushback on them using that information, or really awareness or transparency or control of any kind for consumers in that space. If you think it's bad just when you look in your inbox and you see all these emails from like everybody who shared your email list, with every candidate on the planet. It's much worse in the programmatic data sharing world, and that's where I think there's some awareness and education and transparency that just hasn't happened yet. Maybe it'll happen after this campaign. We'll see more of. Maybe there'll be some reform in the future, but I'm suspicious that will happen.
Mackenzie, anything for you that you're keeping an eye on?
I'm always watching the state laws. I think we have Maryland coming into effect next year that has a lot of provisions that are dissimilar from what we already have on the books. There's a lot of data minimization requirements on top of this, like, prohibition to selling sensitive information. There's a prohibition on targeted advertising to minors at all, 18 and under. We haven't seen a state do that, and it's also a pretty heightened standard on not just minors that are minors, but that you should have known. So it's pretty heightened. And I guess in conjunction with that targeted advertising issue, what the federal bill will do around targeted advertising. Like I said, the first draft said that browsing history was sensitive. So we'll see. There's a lot of reform in advertising right now.
For sure. Okay. We're in and out of here. Go ahead.
Last point, I think there's actually a really good chance that federal bill gets passed in the lame duck session in November, or after November. I think Biden could actually call this is like swan song on privacy and push that thing through, because I think there's bipartisan support for it.
Interesting. Okay, well, Mackenzie, Ben, thanks so much for your time. We covered a lot here in the 50 minutes, so appreciate the time, appreciate the expertise and the opinions, and hopefully we'll do it again in a future quarter. This space seems to be moving very quickly, so this is helpful to everybody here. Everybody, thanks for coming to the Q3 privacy update. We'll see you again next time. Thanks.
Thank you.
Thank you.